everyone. Welcome to Taking the Pulse, a healthcare and life sciences video podcast. I am Heather Hoops Matthews here in the studio today with Maynard Nexsen, healthcare attorney Matthew Roberts. Matthew, good to be back in our studio after being on the road.
Yes, good to see you. Glad we're here in person.
And we are joined today by two more members of the Maynard Nexsen legal team, Mark Moore and Michael Parente, who practice in the firm's government investigations and white-collar defense team. Thank you both for joining us. They are going to share their insights on the recent U.S. Supreme Court rule impacting the Chevron Doctrine and the ramifications in the healthcare industry. Michael, how about you start us off by describing the Chevron Doctrine and why it's important?
Sure. So thank you for having us. So the Chevron Doctrine meant that courts usually deferred to federal agency interpretations if there was a part of a statute that wasn't clear or was missing some key component to it. So if the agency had a reasonable interpretation of an issue, the courts would always defer to that interpretation. So the court wouldn't substitute its own construction of a statute and would look to the agencies for their own interpretation of that statute.
And that was in place. That's been in place for 40 years, roughly.
Since
right?
1984.
Yeah.
It was
right.
Almost exactly 40 years.
So earlier this year, the United States Supreme Court issued a decision in the Loper Bright Enterprises case where it abandoned the Chevron Doctrine. And that's made big news within the healthcare field. Can you talk a little bit about the implications of this decision? Both of you can weigh in on this.
Well, I mean, this is sort of like a life-changing decision here. It's a major decision for healthcare providers, just as it's a major decision for just about any person or entity that does business with the government. Basically, the Supreme Court found here that courts, not agencies, must exercise, quote, their own independent judgment in determining whether an agency has acted within its statutory authority. In other words, you're no longer deferring to the agency for the agency's decision and focusing on the agency's decision. The Supreme Court said that courts need not, and under the APA may not, defer to an agency interpretation of the law simply because the statute is ambiguous. And so when I mentioned earlier, Chevron's a game changer. This reversal of Chevron is a game changer. As the court said in Supreme Court, Chevron previously fostered unwarranted instability in the law, leaving those attempting to plan around agency action in an eternal fog of uncertainty. Now, courts way through that fog and change the rules.
Well, so let's take a step back for a second. So the Congress passes legislation, statutes, and then the federal agencies will come in and promulgate regulations which further the purpose and policy behind the statutes. And what was happening was these federal agencies were issuing the regulations, and then they were interpreting the regulations and how they were enforced or how they impacted folks. And a lot of folks in the industry thought that was going beyond the statutory intent of Congress in various laws, a bunch of healthcare laws. So that being the backdrop, we have now courts coming in and they're going to have to make a decision as to what something means. What do you think the specific implication for the healthcare industry is in light of that deference and on interpretation standard now being gone and relying on the judicial interpretation?
Well, Matthew, as you know, previously HHS and agencies like HHS, like CMS, had nearly free rein to create and implement rules, right? They could implement their rules, regulations, and guidance without congressional approval or without much judicial recourse. Basically, under the Chevron Doctrine, a court had to defer to that agency in its interpretation of rules and regulations. Now, unless CMS, for example, is acting pursuant to express statutory authority, its actions are vulnerable to legal challenges. And courts have already started to declare that HHS has exceeded its statutory authority in rulemaking. I expect that we're going to see a lot more decisions like this, and there are going to be a lot more opportunities and avenues for litigants or potential litigants to push back on agencies' interpretations and to say, I'm sorry, your interpretation is not in line with the clear language of the statute. Court, you should follow the statute, not the agency's interpretation of it.
Do you think the decision will lead to more litigation overall on determining what the meaning of a federal regulation is?
I think Michael's going to handle this one.
Yeah, I think it absolutely will. It gives litigants another avenue to challenge all sorts of rulemaking, not just the regulations, but a lot of agencies have various guidance that gets published. In the healthcare industry, there's local coverage determinations. There's different Medicare administrator contractors that provide different rules all over the country, and those are going to be subject to challenges going forward. Courts have already started dealing with some of these challenges. There have been 2 or 3 cases already where courts have cited to the Supreme Court's decision and have said that HHS and CMS have gone beyond their statutory authority already.
Which is not a surprise to anybody working in the industry. But it's good to hear the Supreme Court say that.
Exactly. And where there's areas where HHS has borrowed from other areas of the law or gone beyond what Congress specifically allows them to do. One example has to do with transgender care, where there was a case where HHS expanded the meaning of on the basis of sex to include transgender care, and a court has now enjoined that action because of the fall of the Chevron Doctrine, because that language is not specifically in the statute.
Right.
So there's going to be more areas like that where the courts are looking specifically at the language of the statute and less at what the agencies are saying to make those decisions.
Well, what do you think, just to give us some specific examples, you have CMS promulgating myriad of reimbursement rules, and then you have things like the federal Stark law or the anti-kickback statute, or things that providers are subject to, that there was a statute and there are all these regs, but the regs have been pushing the enforcement and the policy implementation. Do you think providers will now start pushing back on this, and specifically, how will they push back? Give me some examples of how we're likely to see this increased litigation.
Well, so first of all, you hope to push back to preempt litigation in a number of areas, right? One of the things that we do, and when we work with your team in a healthcare case where we're representing a provider and the government is suggesting that the provider has violated the law, either civilly or criminally, you go back to the government. You address the allegations, and you tell the government why their allegations don't bear fruit or are meritless. Now, with the demise of Chevron and sort of the arise of Loper, what we're going to be doing in cases where we make presentations pre-indictment or pre-charging or pre-filing a complaint with the government, and we're going to push back on those regulations, and we're going to explain to them why the regulation is not in line with the statute and it is not in line with the prevailing law, and explain to the government that if they choose to go down this road, they choose to charge your client, they choose to name your client in a civil complaint, that they're going to have to face this defense in front of a court, and the court is no longer going to defer to them as a representative of the government with their interpretation of the law. So you hope to use it, first of all, to preempt litigation, to prevent the government from making the wrong decision here. If it gets to litigation, then as Michael has mentioned, there are already courts that are holding the government is wrong in its interpretation, and you expect to use that as a defense in litigation.
And Matthew, I think one area you mentioned, the anti-kickback statute, is an area where guidance and regulation has gone far beyond what the statute says itself.
Sure.
And there are safe harbors and all sorts of different components to that law that now are, quite frankly, up in the air. And a court is going to have to decide what stands in terms of safe harbors and what doesn't. But if a client is, or if the government believes that a client has done something that violates their rulemaking, we can present to them that that rule that the government thinks is being violated may not stand up in court.
Right. So it's the loss of a significant advantage that the government had in its enforcement, because they could always rely on that deference to how the regs were interpreted, and now they're going to have to convince a judge that is consistent with the statute.
Absolutely.
Right. That makes it a little easier, but we're going to have to continue to use. Litigation is primarily the only vehicle or the threatened use of this theory in litigation? Is that the primary vehicle that we'll be using this in?
I mean, I think it's the primary vehicle, but I think you can see it in the administrative, and for example, reimbursement, recoupment, proceedings. I think you can see it used there. Agencies, entities may choose to bring DJ actions, declaratory judgment actions, seeking to hold a regulation hold that a regulation exceeds its statutory authority and therefore should be rendered null and void. I think you're going to see a lot of it in litigation, but I also think you're going to see a lot of it behind the scenes, convincing the government that they now need to be reasonable now that this Chevron tool has been taken away from them.
Is it right that the Loper decision doesn't strip away all the deference to federal agencies, though?
I mean, it strips away a basic reliance on the federal agency. You have to now look at as to whether the agency's interpretation of the statute is in line with the statute and the four corners of the statute itself, and look to see whether their position is reasonable or unreasonable. At the end of the day, though, with I think Loper, the bottom line is the regulation or is the interpretation in line with the statute? If it's not, it doesn't matter what the government says. It doesn't matter what how their regulation is drafted. I think courts are going to throw it out.
And the decision deals with federal agencies, but a lot of states like South Carolina do still have deference to agencies. So that'll be an interesting issue going forward to see how courts deal with state agencies' interpretations.
Yeah, it's a good argument, I think, using this. What do you think that will happen with respect to additional legislation that might get passed? We know Congress has been sort of in a holding pattern for, it seems like, decades, where they've not passed a ton of new statutes on some of these areas, and a lot of the policy making has been done through regulation. Do you think this will sort of incite Congress to pass something so they can actually do their job in terms of implementing legislative policy?
It's always hard to answer what might or might not incite Congress or might cause Congress or perhaps the state legislature to move. But I think now that any sort of legislative body should realize that if they believe that a statute needs more in the way of teeth, if they believe that a statute needs more in the way of definitiveness and less ambiguity, it's their responsibility to change the statute.
Right.
So I think that you might certainly see groups lobbying Congress and lobbying state legislatures to make changes to statutes that appear ambiguous. And as to what they will or won't do with those lobbying efforts, that's anybody's guess.
Right. On a related note, we've got an upcoming election that will determine, the presidency, and that will impact the DOJ's policy for investigation, depending on who wins. Do you anticipate any significant change in the way that DOJ will be implementing some of these white-collar crimes or civil investigations in the healthcare space, no matter who wins, or do you think it could be different significantly depending on whether it's Harris or Trump?
I think it could differ depending on who is the winner of the election and exactly how that would go either way. I think that's hard to predict. But I do think that any new administration, because you're probably going to see some changes at DOJ even if Harris becomes president and the party stays the same. I think any new administration is going to have to deal with and grapple with the effects of the abrogation of Chevron and the emergence of Loper.
Right.
Well, this is clearly a landmark sea change for your practice area, and I hope it increases business.
Gives them more arguments to make, which is good.
Right, which is good.
We hope it's going to affect our practice because we think that this puts entities and people who are in the crosshairs of the government, it gives them some new avenues of defense.
Right, right. Mark Moore, Michael Parente, thank you so much for joining us today. We look forward to hearing more, maybe catching up in 6 months to see what happens.
Okay.
All right. Thank you
Thank you
us.
both.
Thank you. On behalf of everyone here at Taking the Pulse, thank you for joining us today, and we look forward to seeing you next time right here on Taking the Pulse, a healthcare and life sciences video podcast.